resume. God save the King. You may be seated, please.
Good morning, Council, and good morning, everyone. You may now be seated. Council, Madam Director, and to you in this formal setting. Yes. Just a minute. Is your microphone?
It's not working.
Yes.
The microphone isn't working, but I can be loud, as Milad well knows. I was in a very reflective place this morning while we were on the parade, And I was thinking that Mr. Rooms has known me and I have known him since I was a clerk of court. And the first time I set eyes on you, Millard, I was a clerk of court in St. Anne as well. And Millard was a prosecutor then. And I was thinking how far we have all come. And I'm just grateful to God for his grace, for having taken us to where we are now, the fact that we are in our right minds, and for the most part, we are enjoying good health. I take the opportunity to wish my colleagues and friends a happy and productive 2026. Millard, you are correct when you say that this is my first opening as an appointed DPP. Last year I was acting, and I acted for a little time. I do not feel as nervous now as I felt then, because there was a lot of uncertainty. I wasn't sure how I got there, how it is I was picked on to become DPP. In fact, last year, April, I was on my way to court in this very courtroom when the telephone rang and the permanent secretary told me to brace myself because an announcement was coming. And that's when I learned, maybe about 9:45 that morning, that I would be appointed to act as DPP. I walked over to court and I pretended, or maybe it was a defense mechanism, but I told no one. It was a secret. And I was addressing your brother, Mr. Justice Pusey, when somebody's telephone went off in here. And the next thing I heard was congratulations, and I wanted the floor to open up and collect me. I'm not in that place today. I am celebrating this achievement, and I hope the rest of you can celebrate with me. Like I said, I am grateful to God. And I think I now know why I am where I am. The DPP's office left the physical structure that we all know to be the DPP's office in November 2024 because of health-related issues. I don't think it is a secret that mold was discovered throughout the building. And in the space of 3 days, we cleared out. My Lord, we have not yet returned to the facility. We have been working from 4 different places since then. And as I stand before you today, the staff is working today from 3 different venues. It is untenable. What it meant for us is that throughout last year, the 3 terms of last year, we were so dislocated that things were not as seamless as they should be. When you have a server serving us from 3 different locations, it leaves some amount of untidiness. Things are disjointed. And sadly, we are still in that place today. We are operating from our registry on King Street and 2 other locations. But there is light at the end of the tunnel because the work that is required for us to return to the DPP's office began yesterday. And so it is hoped that by the beginning of February, we will return home and we will get back to doing the business of prosecuting the way that we know best how to do. Having said that, the DPP's office for the 3 terms last year did the best that we could in the circumstances. And today I can report that a total of 759 matters have been transferred to this sitting of the Home Circuit Court. Millard has a document there, And today is the first time that the document appears the way it does. The lot should have 9 pages there. Normally the statistics is presented on no more than 2 pages. Although we have been dislocated, we have managed to set up our case management digital system, and this is a product of that system. And so the numbers have been disaggregated in a way that it has never been done before. Milord and the court would normally be presented with the numbers of case files only. What is presented here today is not just the number of case files, Milord, but it is the number of counts. It is a clearer picture of what it is that the court has to treat with every day. My Lord, all of us as practitioners are mindful that when we come to court with a case file, when an accused is charged with the offense of murder, more often than not, he's not just charged with murder. He's charged with murder, he's charged with illegal possession of firearm, he's perhaps charged with wounding with intent. This document reflects just that. So it is not just the bare case file and the most serious of offense that is presented here. It is every single offense on every single case file. And this is because of the system that we have put in place in the DPP's office. So it is a true reflection of the work that is conducted here every day, Monday to Friday. I was indicating, my Lord, that there are, from the system, 887 case files for this term. And if you go, my Lord, because I do not propose to go through all 9 pages, we'd be here until 5 o'clock. But I wish to draw your attention to the fact that based on the system, for this term, what is reflected is that for murder cases, there are 351 counts of murder. And for sexual offenses, 278. There are 6, and that's not represented on the document Millard has. There are 6 gang files, and all 6 such files will be before the court this term. Millard, I encourage yourself and my colleagues to look at the document when there is more time to do so, to have an appreciation of how onerous the task is for the term, and to appreciate the awesome responsibility that all of us have as practitioners in this parish only, because this document speaks to this parish only. And when we come to recognize the awesome responsibility that we have, then we come to recognize that we must be present, not just physically, but mentally, so that when we rise to address you, my Lord, we're in a position to say we're ready. We do not say it in court, but amongst prosecutors, we are always mindful of the fact that the witnesses are not at home with us. There is work going on in the background to get witnesses here. We make the telephone calls, the police officers make the telephone calls, the victim support officers make the phone calls. I'm saying that to say that while council has a responsibility, the citizens of Jamaica have a responsibility as well. We are here today, all of us, to do a job. But if they do not come, if they do not participate, the work will not be done. Similarly, the jurors, my Lord. There is an option to have matters tried by a judge sitting without a jury. That's not something that is new in this jurisdiction. It happens every day in the parish court. And it happens in the circuit courts as well, my Lord, when the gun court matters, come up. We've been doing it in the gun courts for years, so it's not unusual. And there has been, in recent time, the option to elect to have bench trials. Until it becomes mandatory, my lord, until there is a change, council will continue to enjoy that right to elect or not to elect. And I will say no more on that. I don't know that it is anything that we need to quarrel about. The law says it's an election. And we continue as council to abide and work within the confines of the law. There is also plea agreement, my lord. And I have been in another forum where I have boasted to other DPPs, to prosecutors Caribbean-wide, that plea agreement, formal plea agreement, is an everyday occurrence here in Jamaica. I don't think there is a week that goes by where a plea agreement is not presented in one of the courts, in one of the circuit courts across the island of Jamaica. So commonplace is it now. It is a matter of cutting and pasting now, my lord. And we continue to approach and confront and quarrel with sometimes our colleagues on the other side about plea agreement. And to give council credit on the other side, they too approach us. In fact, I was indicating to somebody recently that I received 4 letters from one attorney in one day speaking to plea agreement in respect of 4 separate matters. So it is every day and it is commonplace, and we will continue to treat it accordingly, my lord. I've said a lot, my lord, and I like to boast that I'm one of the shy ones. I don't know where all of it has come from this morning, but we look forward to continuing the work that the people of Jamaica have called upon us and paid us to do. We will do our best. I think we will do even better than our best if and when, I'm going to say when, we return to our home office. But until then, we will make the most of the situation and the condition that we find ourselves in. I wish all of us a productive term. May it please you, my lord.
If it pleases you, my lord, Honorable Custos, Rotary for the parish of Kingston, acting Custos for the parish of St. Andrew. At the risk of being accused of competitive, I don't have a competitive bone in my body. Madam DPP indicated just now how long she was acquainted with DSP rooms. And I will not say that I have known DSP rooms from high school days. And I will not say that it was the greatest school of Meadowbrook High School. I will not say any of those things. But it is a pleasure to be addressing you this morning. And may I start officially on behalf of the private bar to congratulate Ms. Claudette Thompson on taking and being appointed as the Director of Public Prosecutions for the island of Jamaica. We welcome that appointment, and we hope that her energy and her style and her professionalism that we have been accustomed to will continue. In fact, we know that it will continue. My Lord and Honorable Custodies, please also permit me to say how heartened I am to see very young counsel at the bar, because in previous times, and I'm speaking of defense counsel now, in previous times, these proceedings have been characterized with a paucity of persons at the private bar. This morning, don't know if it is with influence from the new DPP or the composition of the bench, but I am pleased to see such young, dynamic counsel, it is a good look. I am very heartened by that, and the future looks well in terms of those of us that have been at the bar for some time, myself, Mr. Jenkins, and of course, Ms. Linda Wright. My Lord, in terms of the actual list that is before us, there are a total, as has been said, 759 cases that have been traversed, and a great number of them requires the consideration in terms of the modality of trial, whether it be bench alone or judge and jury trial. It is perhaps fitting that this discussion is punctuated or highlighted by virtue of the fact that this morning in the editorial of the Jamaica Observer, there is an editorial as it relates to the issue of bench trial vis-a-vis judge and jury trials. It is our respectful view, and I think when I speak on behalf of the private bar, that there is a place for both. There are instances when cases are of a particular nature, technical nature, that requires a more discerning dissecting of the evidence. And so one may be given to have a bench trial or to request a bench trial. And of course, there are instances where, based on the particular case, the political sensitivity of it, based on the personalities, it is best for the people to determine the verdict in relation to that. Because ever so often, there is the open criticism, especially on social media, roasting the judges and saying a lot of things that are unjustified. And we should put our money where our mouth is and attend, and I join Madam DPP in saying that the citizens of Jamaica have an obligation to participate in the justice system and to determine what justice is in their community. So I would like to also encourage citizens not to shy away from jury duty, because the myth of jurors being threatened or put in fear or all of those things is just what it is, a myth. So that is what I wanted to highlight in terms of the modality of trials. My learned friend, the learned director, and I say so with glee in terms of her title, my learned friend indicated that we have the right to elect in terms of choice, in terms of modality of trial. But there is this anomaly where even if defense counsel elects to have a judge-alone trial, it still requires the consent of the prosecution. And that is something that I think we need to revisit in terms of review. Also, my Lord, in terms of review, there are many legislation that are either outdated, in need of amendment, in need of review. I know, for example, in Belize, there is a justice board, and they often, on a regular basis, I should say, have a sort of commission where all stakeholders are able to review legislation and seek to improve the system. We may have it here, but if we do, certainly it is not being felt. In addition to that, my Lord, again, I think there should be a timely reminder that in terms of the Prohibition, Restriction, and Regulations Act of 2022, the caution again should be repeated that in its present form, it is going to detract from gains made in terms of the backlog of cases. All cases cannot be tried, and once you have this mandatory minimum period without any discretion being given to the judge, persons are going to want to elect that legislation be revisited and reviewed. So, my Lord, as we move into 2026, on behalf of the private bar, I pledge our continued cooperation, our continued support. There have been much gains, but much more to be achieved. We pledge our support and wish for all a very good and prosperous New Year. May it please you, my Lord, and honorable.
Mighty to please you, my Lord. I'm Joel Nelson, representing the Jamaican Bar Association this morning to bring greetings to the court. I will refrain from repeating what my friends have already said, my Lord. However, from what has been said, I know that we have our commitment and we give our commitment not only to approach the prosecution where possible, but we ask also that the prosecution, where possible, review its files and this that can be taken off the list. Oftentimes, the burden is placed on us as defense counsel to approach and to shorten proceedings. However, we are aware that at times there are files and matters that are on the list for a very long time, and they're going nowhere. And so we ask that the Crown also will review files and those that can be taken off the list, that those matters are removed from the list. Additionally, my Lord, as a bar association, we have a very robust and active criminal practice and procedure committee. And through that committee, we aim at hearing from our members challenges that they are having, and also to encourage our members that where possible to utilize the various tools in our criminal practice management toolkit so that we can move matters expeditiously so that the wheels of justice can continue to turn. We know that there are various stakeholders in this matter of justice, and in order for justice to be served, then we all must play our part. And so we give our commitment, my Lord, to playing our part. And I echo the sentiments of King's Counsel, Mr. Champagne, that as a private bar, we are committed to ensuring that we do our part. And so as I wish for everyone a wonderful new year, and notwithstanding the various challenges that we have had for the past year, we are a people that are resilient, and so I trust that we all will continue to overcome these various challenges and that we will move forward so that the people who await their day in court, not only the accused men, but accused persons and also witnesses, but also as attorneys and other stakeholders, we play our part in ensuring that these matters are dealt with expeditiously through the administration of justice. And so, my Lord, if it is that I can be of no further assistance to the court, that is the commitment of the Jamaican Bar Association and the private bar at large, and the warm greetings that I bring on behalf of our president, Ms. Tanisha Watkins. Mighty to please you.
Honorable Costas and our Costas' representative, SSP Rooms, Counsel, Learned King's Counsel, the learned director, all court staff, police officers, all members of the public, the media included, good morning to you. This is where the country is in a difficult time, we're still reeling from the devastating effect of the hurricane Melissa that hit us not so long ago. One of the results of that being that we have had to have the St. Catherine Circuit Court also convening at this location. But before I remark on that. For those persons who may have had either yourselves, family members, friends, I know colleagues in the judiciary as well as in the various areas of society are still picking up the pieces. And to you all, our best wishes for swift recovery, getting back on our feet. We are also, I join in giving thanks for even the opportunity for us to have a relatively normal opening this morning, notwithstanding all the changes. And so for that, I'm thankful. I've had sight of what is a substantial list of matters. And whereas Learned King's Council made note of the number of council present, I expect it may, in part, be due to a particular matter expected to start this morning. And as I give thought to the fact that we have that matter to start this morning, it reminds me of remarks that would have been made repeatedly in the past regarding the need for specialized environments to host such matters, given the very difficult logistical challenges that they present, not the least of which security, as well as the housing of respective counsel, as well as for the defendants themselves. And as such, with all that is happening, it underscores the need for such a specialized environment to be established, built to accommodate such hearings. Because as we no doubt counsel will appreciate, and the users of the court will appreciate, with this, the matter that is expected to begin, it has displaced the other courts in terms of the housing of other defendants, and and also persons being ushered into the courtroom, and the managing of the court, limited court resources. And so it underscores that need. There is a substantial list, as is mirrored just all over our country. And they all seem to, well, I must admit that murders, gun-related matters, as much as gun-related matters are dealt with in a different court, and sex offenses dominate the list. As the learned director has outlined, that there are several gang-related matters that are expected to be case managed and heard during the course of this term. We are mindful of the need to make the best use of the court's resources. The list is substantial, and I accept the assurances of both learned counsel for the private bar and the learned director on behalf of the public bar, that efforts are going to be made to ensure, as much as the list in this court will be managed in another court due to the logistics of the ongoing matter, or the matter expected to be started. The learned Chief Justice remarked recently of the need for, as much as we acknowledge that plea negotiations are often entered into as between the office of the DPP and members of the private bar, but a more proactive approach needs to also be employed so that the office comes prepared with a position that learned counsel, where of course their clients are guilty, can give consideration to. Plea bargaining is one of those measures that certainly will aid. Other jurisdictions that can boast high turnover rates also have substantial plea bargainings, and so the burdens on their courts. We are trying substantial numbers, and we can't try our way out of the backlog that we have. Until there's a mandate for some more matters to be bench trials, it is as it is. And I did hear a recent hue and cry that the office of the DPP is not accommodating enough for those requests. But we hope that perhaps there's a meeting of the minds, and certainly it will aid in bringing our list to something more manageable. Now, I have taken note of the learner director's indication that they're, notwithstanding the logistical challenges that they have, which they anticipate being resolved shortly, that they have managed to implement digitizing or development of their case management system. And some of these processes are also underway, some of which have been started at a pilot level. Some of them have actually been established here as well, and we expect that all this will augur well for the efficiency of our justice system. The importance of witnesses cannot be underscored, as well as all players, to include jurors where jurors are required. It is incumbent where matters are required for jurors that members of the public who are served make themselves available to play their role. It's so convenient for many persons to stand to the sidelines as we hear the cry for justice. But when the opportunity comes to sit, to discharge a very important civic duty, well, many times persons fall unfortunately ill, or their demands at work or otherwise are so pressing that they need to be excused from jury duty. The role is very important, and I believe that members of the public's role in the discharge and the administration of justice in that regard is also very important. We're not yet at the place where, notwithstanding that in the gun court, there are many matters that, but for the use of a firearm, would have been jury trials. So there is precedent for bench trials in those types of matters. It's not for me to say how legislative change should occur. But it is no coincidence that prior to the mandatory sentencing regime that Learned King's Council made reference to, that the backlog, there was no backlog in the gun court. And so the ability of the court to manage the flow of matters, it is not insignificant. As I said, we can't try our way out of it, but it has a significant impact on the way matters flow. I am grateful for and accept the assurances of counsel on behalf of not just myself, but also my learned colleague and colleagues before whom you will appear, that the assurances of that persons will, I inferred in it that persons will be on time, that persons will make themselves available to ensure that their matters are dealt with promptly, and that where possible, plea agreements can be entered into. Regarding the matter expected to start this morning, we expect that it will displace several of the other courts in terms of either the availability of counsel or the physical space being used, and for that we can only apologize. As I said, it underscores the need for environments to be established that can accommodate these matters because of the obvious logistical challenges. We are operating in a difficult environment in relation to the need to have matters being disposed of quickly, and as such, the need for that type of environment is essential. All right, well, we do have quite a bit of work to do. and as such, I will not detain us much longer. I propose that we would, unless there's anything else that Learned Counsel or anyone wish to indicate, I will rise for a few minutes before we'll return to our substantive list. But before that, let me extend to all my wish that we have a very productive circuit all around, that we're able to discharge of the matters, that where things can be agreed, that they are, to shorten the pace at which we go, and that we will keep in mind the need for the prompt, efficient discharge of the administration of justice in our country. If there's nothing else to address now, I'll rise for a few so that we can attend to. Yes.
Stand, please. This honorable court rises.